I'm
So
out.
got things I need to update people on. Everybody get ready. You're gonna love this. I got nothing. We're going right into the Christmas. We got no crazy laws that have changed. Okay. For January the 1st, we do have new laws that are impacting us. So pay attention. We got a couple of them. Okay. Number one, first and foremost, is that damn refrigerator, oven, stove law. Those need to be in place by January 1st of all new incoming tenancies in order to make that happen. Okay. So we now supply refrigerators and oven stove combos. If the tenant wants to use their own, just have them put in writing that at this time they wish to use their own refrigerator or their own oven. And know damn well that if it breaks at 3 o'clock in the morning and you get a phone call, you got to fix that like it's a water heater. Okay. They now have the same power as a water heater. What do you mean, Patti? A water heater. We have to provide it. If it doesn't work, they don't owe rent. Same thing applies for a refrigerator starting on January 1st. Okay, it's a habitability issue. Simply said.
Patti, on that same topic, so if they sign the addendum saying they want to use their refrigerator and their refrigerator breaks at 3 in the morning, so then we're responsible for the repair even though they signed the
Don't
addendum?
repair it. Put in a new refrigerator. You got to put one in anyway.
Oh.
Well,
Okay,
I would
got it.
never repair a tenant's appliance, just like you wouldn't fix their car when it breaks.
Yeah, true.
Same
Okay.
concept, okay? So we don't want
Got
to
it.
fix their appliances.
What about their caviar and their filet mignons that went bad because the
I hope they
refrigerator?
have renter's insurance because that would cover their personal belongings.
And if they don't?
That's on them. Your lease contract advises them to get renter's insurance to cover their personal belongings.
But if we provide the refrigerator and they don't have renter's insurance,
It's a shame they didn't have the proper protections to cover their personal belongings, isn't it?
okay, so we're not responsible for replacing their personal items in the refrigerator that we provided legally under this. I'll just be
At
nice.
this time, it's a gray area, so we're just going to say no. Okay? Until they tell us yes, the answer is no.
Okay.
Okay? In other words, don't make yourself sick about it. I
Okay.
had somebody that told me that the refrigerator went, oh, let me tell you guys a story and you'll go, wait, what'd she say? I got a doozy for you, okay? A landlord decides to rent their house after they've lived there for years. In other words, it was their home. They bought an upgraded model. They moved out. We rented the house for them, okay? So, husband and wife and 4 little kids. They had 2 sets of twins. I think they were 8 and 11, the sets of twins. So, 4 kids, 2 adults, rent this house. They get up in the morning and come downstairs, and there's somebody passed out on their couch asleep. Their refrigerator's wide open, and all their food's ruined.
Yes.
What the hell? So, they go wake the person up, and the person tells them, I used to live here. But you could tell that he wasn't all there. And he said, I made a mistake. I'm sorry. This is my parents' house. I used my key. I let myself in. I'm sorry. I'm leaving. I get a phone call saying, hey, the parent's son is here. Apparently, he's on the spectrum because he didn't remember his parents moved. He came in. He went to make a sandwich. He left the refrigerator open. He fell asleep on the couch. Let me tell y'all something. That's how it played out to the tenant. He's on the spectrum. Hell no. He was drunk. He got drunk at the bar and his buddies drove him home, only they drove him to the wrong house. He used his key, let himself in, went to make a sandwich, realized he was in the wrong place, and passed out on the couch. I would have shot him. Just saying. You wake up and find somebody passed out on your couch? Are you going to shoot him? Are you going to poke him and wake him up and ask him who they are? No. Okay. In that particular incident, I replaced the lock on the front door, told them they were correct. The son was on the spectrum. I didn't tell him he got drunk. That's none of their business. And apologized profusely. And I told the owner, go buy him a $500 gift card to Vaughn's and give it to him to tell him you're sorry. and be grateful you're not planning a funeral.
Or that they're not suing them for not changing the locks.
There's no law that says you have to change the locks. I'm unaware of a law. People keep talking about this bullshit law that doesn't exist, and I'm unaware of.
Yeah, but you could come up with this. I mean, negligent infliction of emotional distress.
I get it. I get it. But there isn't a law that says you have to do that.
The car form has a box. The premises has not been rekeyed.
That's you telling the tenant, yes, it has, or no, it hasn't, and putting it in writing.
Yeah,
That's all.
just boilerplate.
And let's be realistic. I don't know about you guys, but anytime I buy and or rent something, the very first thing I do, the second it is mine, I go change the locks. Even if I'm renting, I don't know who has a key. I know it's a violation of my written terms, but you know what? I have no problem giving a copy to the landlord. But the very first thing I do is go change the locks. I don't know who has a key. I don't.
Yeah.
And that's just human nature in my book, but that's me. So it's something that we all do anyway. And now I lost my train of thought. What were we talking about, folks? We were talking about the new laws that are hitting us for January.
Refrigerator stove.
Everybody got that, right? The other one that has to be done by January 1 is your balcony inspections. They are not going to extend it again. Do not feed into that. They extended it last year and gave us another year. They're not going to do that twice. I get asked an abundance of questions regarding the balcony laws. Look, they're in play because a bunch of people plummeted to their death because it wasn't structurally sound. Okay? We're talking about protecting people. I'm all about it. I'm all for it. It's not just balconies. Pay attention, I may ask questions later. It is elevated walkways. Example, you have an exterior staircase at a community going up to the second floor. And on that second floor, you have a landing that goes across where people can go into their front door. That is considered a balcony and needs to be inspected. Okay?
The walkway?
Yes. Elevated walkways, stairwells, exterior stairwells, elevated walkways, and balconies need to be inspected. Okay?
Yeah, it's covering your assets.
Everybody keeps asking me, who do I turn this into? What do I do? No, you don't understand. And Chris is going to pipe in and go, yeah, she's probably right. Because we've been given an ultimatum and a deadline for having this balcony inspection done by such and such date, I don't think we have to file it with anybody, okay? It doesn't get filed with the county or the city or the state or anything along those lines. What's going to happen is when we get into eviction court 5 years from now, they're going to ask us when our last balcony inspection is. And if we don't have one, they're going to scream it's a habitability issue and we have to refund the rent.
Maybe, but the bigger issue is, frankly, if like somebody does fall and get hurt, that's just boom, slam dunk.
Yeah,
Probably
right.
won't even go to a jury because it's like negligence per se.
Yeah. That's like pressing the gas instead of the brake. You goofed. You pay. Okay? So this isn't a joke. You have to have your elevated walkways inspected by January the 1st. You don't have much time left. All right? Those are the two big ones that are hitting us on January 1st we need to be aware of. Other than that, I think that everything's pretty smooth sailing. The recent changes in LA turned up no additional 1% for the mom and pop. Wait, what? They were all go giddy on giving mom and pops with 10 or less doors, letting them self-certify that they own 10 or less units and allowing them to charge an extra 1%. Why did they not let us win that, Patti? Because, you're going to love this, landlords shouldn't have the capability of doing their own certification saying that they own less than 10 units. Pause. Wait a minute. Did we let tenants self-certify that they were affected by COVID based on their word? The table's turning, and they don't want to give us the other side of the coin. We lost the 1% for mom and pop owners because they didn't believe we could successfully self-certify. But we let them do it all through COVID. I have a tenant that sent me a certification every flippin' month, like clockwork. But we're not mature enough to self-certify? Sorry, I'm a little pissed about that. I'm a lot pissed about that. But it just goes to show you how much of the bureaucracy and bullshit is taking over controlling. Also, they haven't done it yet, but I know it's coming. They're going to raise the amount of relocation fees. They have to. It's been $20,000 for way too long. They're going to increase it. Trust me. It's not a matter of if, it's a matter of when. Okay? So, balcony inspections, refrigerators, stoves, and ovens have to be in place for all new incoming tenants and anybody that's renewing.
Now, month to month's not a renewal, right? Or is that
Here's where it's a gray area, okay? And just hear me out. A month to month renews every month, correct?
yeah.
That's how I see it too. But it isn't written that way in the provision. So most attorneys are saying no, at a new rental or at a lease renewal. But in my mind, that means every month if they're on a month to month. So my opinion is cover your ass, put it in an addendum, and have them sign saying that they're using their own. I mentioned this to Dan, and he said, you can write it and I can give it to our members, but it's not necessary, Patty. It's only on renewal. Yeah, but a month to month renews monthly. Sorry.
Yeah.
Sorry. That's just me working in a law firm and looking at the defense side of things, okay, instead of the offense side of things. I look at things in weird ways because watch, you guys are going to laugh as, oh yeah, you needed to have that in writing. Watch that come out. A month to month renews monthly. So yeah, it just, who knows? I'd rather have you protect your asset and just have the document there. It's not a big deal. It's not a big deal. Put the document there, save your ass, okay? Who should we use, Dr. Balcony, or is there another suggestion? Anybody that gets the AGLA magazine. Believe it's called Apartment Age. Turn to the very back of it. It has a vendor directory in it. I want to say when I looked yesterday, it had 11 different balcony inspectors. So there's a lot of them out there, okay?
Now the fee on that's like what? Under $700, I guess, depending on the size of the property, but it's like $700 for a
Yeah,
standard
but
one.
if you don't need any repairs.
Yeah.
I mean, let's face it, they just keep throwing stuff at it. Okay, Julia's got some questions. Let's dive into her shit show for a hot second and get out of mine. Landlord has to mail security deposit within 21 days, not delivered within 21 days. It needs to be postmarked within 21 days. In the rental agreement, we can go back to including a line item saying the landlord can distribute rent as we choose to, correct? Kind of. We can talk about that very briefly, okay? What do I include in an addendum if I'm allowing musical instruments? You can't.
Wait, sorry, what do you, these are like the
Can't.
perfect tenant or perfect, like everything. They have an amazing credit score, everything, they income qualify, but they did tell me that they have, I don't know, like a piano or like a keyboard thing, whatever. And
Thank you for letting me know and turn your blind eye to it. You forgot. You want to know why?
Yeah.
If they're playing that keyboard at 7:00 in the morning and the cops show up and say, you can't be making all this noise, you don't want them to pull out the addendum saying the landlord gave me written permission to. You
Okay.
cannot give them written permission to break the law. Okay? There is a noise ordinance in your city that says no musical instruments can be played between the hours of, and it's probably 8 a.m. to 10 p.m. That's usually everybody's standard noise making rules, right? Instruments fall in that. So just be careful. Yes, you're allowing them to have it on the property. It's not a non-issue. That way, if it gets a problem in the future, it wasn't that you allowed it, it's you're playing it, it's disrupting the right to quiet enjoyment for neighboring residents and things of that nature. I hope that makes sense.
Okay, got it. Is it, they already marked on the application that they have it, so is it just, again, it's something that I forgot.
Bingo.
Okay.
See how quickly that worked?
Yeah.
Okay. In the rental agreement, can we go back to including a line item saying the landlord can distribute? Now I understand your question. Yes,
Yeah, non-rent items, then
yes,
past due
yes,
rent,
yes,
and then current
yes,
rent.
yes.
Okay, great.
So just so everybody knows what her and I are talking about, and you're like, Patty, is that even in English? Yes. Okay, so let's talk about this. Let's dive into this shit show. Back in the day before COVID, what we do in corporate America is any rents coming in would pay the most previous balance first. In other words, let's say that the tenant owed a $100 late fee. Okay? The rent comes in, the check's for $1,000. We take in the $1,000. $100 of that went to last month's late fee, and $900 of it went to this month's rent. And now what's left over is non-payment of rent of the $100 for this month. Okay? COVID stopped us from doing our accounting that way. They wrote in one of the COVID moratoriums, in fact, it was the one that ends in 828. The first one we had was Assembly Bill 1050, I think. The second one was a Senate bill, and it was 828. And that moratorium told us that we could not do our accounting that way until after October 1st of 2025. That any incoming payments would be applied to the current month's rent, and any overages went to future rents. And that's how we had to do our accounting during COVID. Rent coming in, if it was more than what the rent was, any overages went to future. Nothing went into the rears unless the tenant put in writing that it could be applied to money that was owed in the rears. We had to have it in writing if it was for back months where that money was supposed to be applied. Starting October 1st of 2025, that is off that. That is no longer part of the moratorium from COVID. We can go back to the regular way of calculating money. Example, your tenant's 3 months behind, they give you, and their rent's $1,000 because it's easy for me to do math in my head with $1,000 rent. Okay? They're 3 months behind and they come in and they pay you 2 months rent, right? We're not going to put that on this month and next month anymore. We're going to go back and put that as 2 months, and you still owe me this month and last month. Okay? You guys paying attention? So we can now apply it to the most past due balance before being applied to rent. And that was Julia's question and what we were talking about. And then she had a fourth question. Let me go find it. I have a single family residence with an ADU. They're sharing the main driveway with a bonus parking pad. How detailed do I need to get in the parking addendum? Do I also need to specify that the ADU resident has to use the driveway as a walkway to their ADU? You want to make it simple? The ADU cannot park in the driveway. That way they don't block each other in.
The parking pad I put off to the side. So the resident for the ADU already said, okay, or I told the resident that they can park there. And then so think of like a regular driveway, and then it just has a parking pad to the left. So kind of like an L-shaped. Anyways, the main house is going to park towards the back of the driveway, and then they can all get out as long as, no one.
Just put in there that no one is allowed to block the driveway. Do an addendum for the person that's already in there, and then for the new person, you cannot block the driveway. That's the easiest way to combat the situation for all parties.
Got it. Perfect. Thank you.
Because we could go into detail, but good God, if we got our north and our souths crossed, we could be in a whole west of trouble. So it's just easier to say, do not block the driveway.
Perfect. Thank you.
The driveway and you have them towed, it's a material breach.
I'm sorry, just to clarify, I think I spaced out for a second, but we no longer need to have special language to apply money that comes into arrears. Like for new leases.
Correct.
Okay.
That died October 1st, 2025. unless they pass a new law that I'm unaware of and nobody has yet, we can go back to our old way of doing accounting. We just had to change it during COVID. That's done with.
Rest in peace.
I'd rather say bury that bitch, but okay, we'll say rest in peace.
Yeah, well, I mean, we got supervisors who, vote that there's a declaration of emergency because it rained and not even that much. Isn't there some point where it gets challenged, like to the California Supreme Court, that does not constitute an emergency? There's got to be a definition of emergency somewhere that makes more
Poor
sense.
planning on your part doesn't constitute an emergency for me.
Wow. They're really stretching it, man.
There,
There needs to be a limit on what an emergency is.
that's just freaking ridiculous because it's also the differences of us telling our tenants, I'm sorry, I don't govern noise. Please contact law enforcement. And them saying, it's not loud enough for me to call the cops. Well, then there's nothing I can do about it either. David, I'm interviewing a new client. A lease he sent me from 1985 is a handwritten 2-page document. This is in Hollywood. Can I have him sign a new current lease? I'm going to assume it's in West Hollywood. And if they will, yeah, but hold on to that old one. It might control. You guys have no idea. The best lease I ever saw was written on a yellow legal pad.
I wish I could upload this 2-pager so you can see it.
You should see some of the stuff that I have in writing. It would make you throw up in your mouth. But I picked it up at the law firm and I'd always ask the people, may I please keep a copy of this for educational purposes? And they'd say, yeah, of course, Patty. Okay, great, because I'm going to teach other people. Don't do it like this.
It's
Don't
actually
do it
in
like that.
it's actually in Hollywood, not West Hollywood. So it's
Okay,
still
but
city of LA.
West Hollywood would have made it worse, is why I said it's probably West Hollywood.
Yeah, no, just regular Hollywood. And I know that if it's same price and terms, you can have them signed, but 2 pages handwritten from the owner.
So the
Yeah.
way I look at it is a lot has happened since 95 or 85, whatever year you said. And there's a lot more disclosures that need to be given and a lot more rights that tenants need to be notified. So by putting you on a new contract with all the new addendums, it lets you know what all of your new rights are. Oh,
Yeah. Anybody
sold.
want this property in Hollywood? Because I don't want to deal with it. I'm in Pasadena. So if anybody is interested, you can have it. No referral, no nothing. I just don't want it. So let me know in the chat box.
Does anybody want to take over management on a property in Hollywood? Please advise.
It's
Okay.
a fourplex with 2 vacant units that are new and then 2 established tenants. So you can lease out the other 2 and then manage. Yeah.
Okay, Erin, you're scaring me, girlfriend. Let's read this. Patty, with the emergency storm declaration passed in unincorporated LA County, I didn't know that it passed in unincorporated LA County. Somebody please verify that. I am trying to have a unit I'm trying to rent. The unit has been vacant for over 6 months due to renovation. Oh, girl, I don't think it's about the storm. Okay, so there's emergency declarations in place already because of the last flood that we had come through. That expires, or it's the fires, something, but it's the fires. It expires on January 7th. So list your property for rent for market value on January 8th, or list it now that says coming after January the 10th and list it at market value.
I thought there were exceptions if you made capital improvements.
I get that. That's all up for an attorney to argue. I'd rather just keep you safe.
No, I mean, I think it's like written in there somewhere. I don't think it's an argument. I think there were exceptions. I just don't know what they are. I'm sorry.
Okay. And my theory is it's 3 weeks. Wait 3 weeks. Right?
Unless they extend it again.
I got an email from Agla at 11:37 a.m. It was extended to January 28th of 2026. Yeah.
Right. I was just looking for that email because I saw it and was
Okay, you guys got to remember, I don't get Agla's emails until I get back to work tomorrow morning. I'm off Tuesday, Wednesday. Sorry. So sometimes you guys know before I do. Sorry. Okay, so they extended it to January 28th. You're not bursting my bubble. Thanks for letting us know. This is a team and this is how we work. See how that worked? You're not bursting, Aaron. Never, ever. So Chris says he remembers seeing something in that moratorium for the price gouging due to the fires for allowing capital improvements. I'd have to read the state of emergency moratorium guidelines to see if there's anything under there and what
right.
they consider.
I'm just looking at the Agla editorial because I read it and that's where I got it from. It said there are some narrow exceptions. However, we strongly encourage owners to speak to legal counsel as to their specific situation. But I do think
So
they've
again,
usually
we're right back
been
to what an attorney's willing to argue.
right, but I do think there have always been exceptions to the 10% anti-gouging rule for,
Major renovation.
capital, right,
Hey,
capital
look
improvement.
at it this way. I worked in a law firm when this law was first enacted, the 10% um, in a state of emergency. Okay, it's actually California Penal Code 396, subparagraph B, off the top of my head. It's penal code, not a civil code. 396, paragraph B, speaks about rental housing, specifically rental housing in the state of California. Okay, when that came out, I want to say it was 2016, 2017, maybe 2018. I'd have to go look. Okay. But when that came out, I had attorneys immediately tell me, well, I'd argue that we did capital improvements. I mean, the tenant moved out, destroyed the property. I did 80 grand worth of renovations. So it's all up to what an attorney is willing to argue. So I think your question should be to your legal counsel, and it should go something like this. Hey, I just want to let you know that I had a question. I want to put my house back on the market, but I want to put it up for more than the 10% that the moratorium's saying because I did renovations totaling $40,000. Is that something you're willing to argue in court, or do I need to stay under the 10%? Because at the end of the day, it doesn't matter what I say, it doesn't matter what Chris says. It matters what the attorney that's standing next to you defending you has to say.
At
So that's
525 an hour.
hey, but that's who we need to call and ask, let's be honest, because that's who's going to be standing next to us in a courtroom. I would argue all day long if I put in $80,000 worth of renovations that I have a right to raise my rent more than 10%. Specifically, if the resident applying for my property is not a victim of the fire. So it just depends on each individual circumstance on what you can and cannot do or what your attorney is willing to argue. I can't believe that they freaking extended it. They only got 28 days out of them because we didn't want to give them another freaking inch of time. And now apparently we're giving them an additional 28 days. Yeehaw. Why? Are they going to pass some new law or try to pass some new law across the state or do something crazy? Who knows? But they're milking it for all they can milk.
Patty, is it 10% more than the previous rent, or is it 10% off of over something else?
10% above the last rent amount.
If it rented in the last year, if it's been more than a year since it rented, there's like 160% of HUD, which can be not good if you're in certain neighborhoods where there's a big um, difference between the average house and your property.
Okay, great, thank you.
But there is all, but I threw it into like AI, and consistently I'm seeing a defense or an exception that if the price increase was due to additional costs of the materials and or labor necessary to sell your product or service. So I think, like if you had to do a lot of repairs,
Upgrades,
it kind of
paint, flooring,
probably
cabinetry, roof.
Right, but it depends on whether it's like, taking care of ordinary wear and tear, like, or if it's really like repairing like damage from
Look, if
somebody,
if it's
or an
doing,
improvement, like a capital improvement because you
do
renovate.
some capital improvements while it's vacant, so your attorney has a better argument for you, and I think you'll be fine.
Okay, that sounds good. Thank you.
Do some good capital improvements. I mean, you might as well. Hang on. Ivana. This townhouse with 3 rental units is under Larso. I would like to increase the rent. Can I only mail the rent increase with the notice, or should I also post it on their front door? I mailed the latest RSO certificate, rental protection, etc. on 8/25. Do I still need to include these along? Yes. So my theory is every time you serve a notice, serve them with the tenant's rights, the right to counsel, your certification permit being current, and the actual notice you want to give them. Okay? Every time you serve them a notice, it wouldn't be a bad business practice to include LA City's bureaucracy and bullshit each time, so that when you get into court, or if you get into court later down the road, you can tell the judge, opposing counsel, whomever, that not only do you have it posted on the property, anytime you've served a notice, you've included that as well. So it works perfect. And the best way to increase rent is to personally serve them. Only mailing them is not allowed. It's a post and mail, okay? So a rent increase letter would be posted on the door and mailed same day. Because it's a rent increase, I always send it certified mail. Okay? Rent increases or terminations of tenancy, I send certified. Everything else, I send snail mail.
What the hell? Hey, I can't hear you.
You guys want to know something funny? I got a phone call and tried to disconnect the phone call, and it shut off the Zoom meeting. So I don't know how you guys are all still on here, but I just had to log back on. That was awesome. Oops, I goofed, but here I am. Can you hear me now, Chris?
Yes.
Okay, perfect. All right. And then please remind me what we are, I can go back. So, you want to personally serve, and then, if you have to post a mail, you want to do certified because it's a rent increase. And I don't suggest subservice on a rent increase notice, but personal service is always the best. Julia, if my family trust owns the property, do I need to put the trust name as the owner on the rental agreement? Yes. That is the landlord of record, whoever is on title.
Technically, it's the trustee of the trust, not the trust.
Thank you. So you could put the trustee information, all of your name as trustee for the blank, blank, blank trust.
You don't need all trustees on there because presumably every trustee has the power to do that in the trust document itself. So,
There you go.
anyway.
Is
Okay,
it
so
really-
then it would be like Julia, trustee of
It'd be like Julia as trustee of the whatever
blank,
family
blank,
Whatever
living
trust.
or
Oh, okay.
family trust.
trustee. Okay, gotcha.
Use
And then-
however your trust attorney told you to do things. Like if some do like UDT for under a declaration of trust and a date. Sometimes people have like as restated and a date, or as amended on and a date. Just to
Yes.
be really specific about it and not, uh, I don't know. You don't want to get.
I don't think that we need to get in that specific on a rental. I
But
think
I
you're
mean, I
going
don't.
to-
With these communist judges, like I wouldn't put them past anything.
She's in San Bernardino County, not in LA.
Oh, okay, never mind.
Thank you, Chris.
It's
But I
so-
was only asking in regard to, and a family trust isn't the same thing as a real estate. What is it called? Real estate investment trust.
No,
And
they are not one and the same.
No, a real
Okay.
estate investment trust is like actually from the tax code. It has nothing to do with
A real estate or a REIT, a real estate
Yeah.
investment trust, basically you put your money in a REIT, just your money, and it's like you belong to a pool of money that bought that huge apartment complex. Your portion probably covered the umbrella by the pool. But a real estate investment then sends you a check every month,
Uh-huh.
whether or not the people paid the rent or not. But it's not, it's a very small return on investment over a course of time is how you get your money out of a REIT.
Oh, okay.
As
And I
far
was
as
just
I'm
asking,
aware, there are only 2 REITs still left in California. They're trying to eliminate them entirely. You can no longer invest in California in a real estate investment trust. However, there are still 2 that are alive and kicking. You just can't get involved in them if you aren't involved in them already. So there's
hmm.
2 still alive in the state of California.
Like private ones, because there's certainly all kinds of publicly traded ones you can buy that I can't imagine wouldn't own any property in California.
Real estate investment trusts are no longer allowed in California. It's been that way for a long time.
Is that commercial as well as residential?
I can't answer that question.
Attorney, is that commercial or?
I don't know. I don't know.
He's
This is the
unaware of
first
what I'm
time I've
saying.
ever heard of this,
Right.
of that. I just know REITs are, it's, there are specific requirements. They have to distribute a lot in dividends. It's from the tax code. It has nothing to do with like how any of us are going to own real property.
Bingo. There you go. So no, it is not the same.
Okay. And the only reason why I was asking was because on the AOA forms, now it's putting a section for the mandatory offer of credit reporting. And so I don't think I have to do that. So, but
No, not unless you own more than $14 at one address.
no, I don't.
So
Okay, thank you.
multifamily dwellings require credit reporting now
Okay, got it. Thank you.
at the tenant's request, not to freak anybody out.
Anyone there knows of a good REIT to invest in?
No. Patty, you said about the reporting, isn't anybody under 16 units exempt?
Yes, if you have more than 16 units, you have to do the credit reporting and offer that to your tenants. 16 units under one address is how I read the provision.
Yeah, but they can opt in or opt out. It's,
Only if they have more than 16 units on one parcel.
yeah, but the tenants of more than 16 can opt out, right?
Or opt in, correct. They
Yeah.
have to want that. But if
Yeah.
you have 3 doors and your tenant wants credit reporting, too bad, so sad. Sorry, I can't help you. And the only reason I say that is, could you do it? Yeah, probably. But why work harder?
Yeah.
I'm all about working smarter, not harder.
Speaking of which, does anybody know on the CAA website if there's a way to get printable forms by their number? Because their instructions refer to these forms and then I can't find them easily.
If you search just the form number, will it pull up?
That's a good question.
Not trying to be an ass, but that's how I always searched for CAA, was by the form number, and they
Oh
could.
yeah, that does work. Thank you. Sorry.
No, don't apologize. Teamwork, remember? Because I used to have them by numbers so that I could just type in the number and hit print, type in the number and hit print. That's how I remembered. So, no, and don't apologize ever. I'm the one that thought 4-wheel drive meant you could turn your back tires. Don't ask.
Do you?
One.
I can't
4-wheel
remember.
drive.
I can't remember what the number is. Do you remember does anybody know what the new form is for like where you can get them to agree that you're going to send the disposition of security deposit and the evidence like the photographs by email? Because that's
One of the places that I saw that was on the itemized disposition of security deposit. I think it's in their acknowledgement to vacate or in their right to an initial inspection, because those would be the places that would poke in. Does that make sense?
Yeah, I thought I know I saw it on one of those originally. I'm just trying to find it.
It's okay. I have a friend that works there. If we can't find it, I know who to call. Just let me know. Okay.
Patty, I'm on CAA's website, and I've never used CAA before, and I was trying to find the pricing, and it said to get a quote. Can
They
anyone tell
charge
me the
you
ballpark
per
of what?
door.
Oh, okay.
Okay. So I'll give you an example. They have a flat fee if you own one door, and I'm going to throw numbers out there. I may not be correct. Do not quote me to these numbers. Okay. They may say to be our member, it is $399 a year. And for another $100 a year, you have access to our forms, our online fillable forms. And then we're going to charge you an additional $4.50 for each door you have. Okay.
And I think like they charge you extra if you're in multiple counties. Like they have some funky
Okay.
scheme.
Okay. So they nickel and dime you, but that's how they do it is they start with this is how much we are per year for one door. And then we charge you $4.50 for each additional door, or $2.50 or however much they charge. I don't quote me to the price. I'm unaware. And then they do charge you additional for being able to use the online fillable forms.
Which are awesome, by the way.
Well, buckle up, Chris, because starting the first of this year, Agla's doing
Agla.
online fillable forms also. So Agla's following suit.
Just get Dan to do the advocacy thing, and then I'll be really happy.
I'm working on it, man. I got two hands.
I
We can
know. I
actually
know.
go meet with him, and he has a crew that helps with that. So that's who I need to present that to.
Anyway, it's just I don't know if anybody else has done it. I know I sent it to Arlene. I don't know if Arlene's here today.
Arlene is at
No.
Agla for a lunch and learn today. She's
Oh,
not
right.
here.
She's at that thing. Okay.
Yeah.
I don't know, but CA does a fabulous job now of like when there's a red alert or whatever for like the city council or the supervisors, and they send you a thing and like literally takes less than 60 seconds when you know what you're doing, where you like put your email and your address of your property and business address and um, you know,
To help
your
fight.
name and whatever, and like basically
Right.
they send you a confirmation number by email to make sure you actually control the email and you're not just spamming, and like takes less than 60 seconds, and it emails like all these deputies of the entire city council. So it's
It sends your voice where it needs to be heard in a rapid fashion. Only takes 60 seconds to do it. If
right.
Agla
It's
has the
really
cap,
efficient.
right, and I've talked to Dan about Agla having the capability to build the same type of system so that we can be on board with helping put a stop to the
Or I
bureau.
don't even know that he needs to build it. Maybe it's just something like a same vendor they could use or something. I don't know. I'm just
I
why
got a way to figure it out. Just hang tight, sir.
don't reinvent the wheel.
No, but I know somebody that knows how to go borrow the wheel. All right. Does anybody else have anything? Otherwise, I'm going to get off of here. But otherwise, I'm wide open for questions, concerns, problems, issues. And even if you just have something you think stupid and you're embarrassed to ask, don't be.
Okay.
Patty,
Yeah.
yeah, Patty, I'm wondering about this refrigerator stove problem. And most of my tenants have their own upscale refrigerators and stoves. So what do I do when
Honey,
they
I want you
go
to go to
out?
your tenants. I want you to go to your tenants and I want you to take a blank addendum. Blank addendum. Okay?
Okay.
And I want you to tell them, hey, a new refrigerator law just passed saying that I have to provide a refrigerator and a stove oven in here. And I
No,
know
no,
that
no, no, not have to if you request, but it doesn't say it doesn't say anything about how nice it has to be. It has to be like adequate for the place. So what I would do is say, look, I'm just not in a position to buy everybody brand new deluxe refrigerators. So if I end up having to replace this, it's not going to be as nice. So
that's I was headed that way, Chris, but yes, okay. So I would tell them if I have to put a refrigerator in here, it's going to be a very basic model. And I know that you have a very nice refrigerator. So if you want to write here that at this time you choose to use your own refrigerator and sign and date it for me, I'll put that in your file so that we don't have to replace it with the hunk of junk I'm going to put in the hole.
That sounds great because I
But
can imagine the
sugar coat it. Don't use hunk of junk, okay? But
I can
Basic
imagine
model, I
them
think, is a
saying,
great.
"Well, you just give me the money that you would pay, and I'll buy my own Sub-Zero." So
right?
I don't have to give them an allowance on their fancy appliance.
No.
Yay.
They are putting in writing that at this time they choose to use their own, and that's all that's required. Once they
Okay.
vacate, you need to fill the hole.
Should well, I do have a vacancy. Actually, I have two, but should I was thinking that when I do the rental application, I can ask the people if they have their own and they want to use it, or if they need me to replace, if they need, because normally I don't apply, supply appliances.
I understand that. And look at it this way. For all new incoming tenants, we're supposed to supply them. And it's a habitability issue if it breaks, so they don't owe rent until we fix it, just like
Okay.
a water heater.
Okay.
So for new incoming tenants, I would put those in there. Somebody asked me a great question. I don't know if it was you, Linda, but I'm going to share it today because it made me go down the rabbit hole in my brain. I said, Patti, why aren't we saying that the rent is this much with a refrigerator, or we're doing a discounted rent without the refrigerator and they can bring their own? That's a great idea. But now they're at a lower rent and their refrigerator broke and you have to put in a new one. And now they're paying lower rent. So I see that as a problem. Don't go that route. Okay. Just saying. Um,
I agree.
yeah, somebody planted the seed of we could offer a lower rent if they bring their own refrigerator. And I thought it was a great idea until I played it through and said, yeah, but that refrigerator now breaks. You have to put in a big refrigerator. You can't do an illegal rent increase, and now you're at the lower rent amount. So don't make that mistake. We went down the rabbit hole to see how that would play out. That isn't going to work. Don't go for it. Buy a refrigerator, put it in the hole. That's the easiest way I could tell you. It's a habitability issue. If it doesn't work, they don't owe rent.
Awesome. Well, I have another problem, a bigger problem, which is I have a death in the unit, and the person has apparently no next of kin. Do you have an attorney? Do I need an attorney for this? Because the house is locked down now, and I don't even know where to start, and it's the holidays.
Uh-huh. The coroner has said that there's no next of kin.
No, they won't return my calls.
They
Surprise.
might be closed until January the 3rd.
Okay. Okay.
But hear me out. Keep getting on them, keep leaving a message. There is no next of kin. I am going to bag up their personal items. And honestly, let me ask you this, and I need you to be honest with me so that I can help you better. Okay?
Sure.
If you gathered up all the shit left in that apartment, okay, all of their personal belongings, at a yard sale, would that be less than $700 or more than $700?
The tenant claimed she was an actress in Star Trek years ago, and she has a lot of Star Trek paraphernalia, which she claims is very valuable. She's got one car garage full of stuff and her house full of stuff. I would say, honestly, probably more than 700, but I would have to have it appraised. My son-in-law is a Star Trek buff, and he says definitely worth more than that.
Okay, so you're going to have to do a notice of right to reclaim abandoned personal property valued at over $700. You're going to have to hire an auctioneer and have a public sale of these items, okay?
Okay.
You can pay the auctioneer, you can pay for the public sale, but then you have to send all the money that it makes to the state of California. You don't get to keep it.
So what about, she was a lifelong smoker. So what about the repair to the house, the nicotine stained house?
Tough shit.
Oh,
I mean,
yeah.
I could say that in the nicest way and go down the rabbit hole, but the reality is personal items left behind become a ward of the state. The state then determines what happens with that money. Could you
Well,
file a grievance with the state saying that you're owed that money? That's a rabbit hole of law I don't even want to go down.
but you can take it out of the security deposit, no?
Yes.
Okay.
You can take it out of the security deposit. Okay?
Well, that's a pretty sad security deposit considering.
Honey, I get it. I understand and I know, but without next of kin, they have no advocate to speak on their behalf.
So if I found the next of kin who's actually homeless, I'm afraid that she's going to move into the house.
Again, that's why I suggested removing all the belongings from the property. So if someone comes out of the woodwork, it's not even in that house anymore, and that house is no longer in question.
I see. Okay.
They're in a storage unit until the public sale.
Is the premises considered abandoned if nobody comes out of the woodwork to say they?
I do a notice of right to reclaim abandoned real property, not just personal property.
Right,
Real
but-
property to become yours 18 days after the rent's left unpaid.
Right, but you need to do that too, right? And then
Yes, I do them both.
Right, then you can take possession and store everything and secure.
So you
Yeah,
need two notices, right to reclaim abandoned personal property valued at over $700 and the right to reclaim abandoned real property.
What do you think about like
And wait, slow down, hold on. I'm going to tell you guys right now. You guys are going to tell me it's really hard to find a notice of abandoned real property.
no, thank you.
You're right, it is. And you're not going to be able to get it from your attorney because they want to sell you an eviction for possession.
doesn't Agla have them?
Agla might have a notice of right to reclaim abandoned real property. I'll have to look. I remember fighting with Dan about 5 years ago for that, saying the attorneys are telling us we can't have, and then I explained to him why, and he understood. Oh, that's why they're not answering me. I'm like, yeah, it helps somebody avoid doing an eviction for possession. Who pays for the storage unit? The owner. But remember, when the owner can allocate their expenses, when they send the money to the state, they can deduct the storage unit. They can deduct the expense for the storage unit. They can deduct the expense for the, the bingo collar, but that's not what they're called. But you know what I'm trying to say?
Auctioneer?
Yes, because it goes to public auction. So whatever the auctioneer charges the owner, they can take out of that money. Whatever storage, they can take out of that money. The expenses to hold the public auction can be deducted from the proceeds, nothing else. So damages to the unit cannot be deducted from that. You have to send the money to the state and then contact the state about the money that's owed to you.
So CAA seems to have a notice of belief of abandonment for real property. It's a form CA 280.
Okay.
And then they also have for notice of right to reclaim abandoned personal property value more than 700. That's CA 282. I don't know.
Thanks.
My suggestion would be to put not only the tenant's name, but maybe put the estate of them if you know for a fact that they've passed. That way.
Yeah, right now it's the estate of California.
No, I mean, it's still that person's estate. You don't know who's going to come out of the woodwork.
Right, and if nobody comes out of the woodwork
Just
and
because it is sheets to the state is the technical term.
There you go.
There's like a Department of Lost Property or something like that, and it stays there for like some statutory period, and I don't remember what it is. And if nobody claims it, then yeah, the state steals it.
Yep, it's exactly what happens.
That's a question on our test.
Okay, thank you, everybody.
Yes, it has to do with real estate law, and that's how that goes. Do you need to hire an attorney? Maybe not, but you definitely need to hire an auctioneer and somebody that is very familiar with dealing with this type of thing.
Yeah, I had to pipe out for a second, but as far as storage goes, I've just been leaving it in the unit instead of doing all that work. And
It all depends on how much shit is there. I mean, look at it this way. If this person was an actress of a movie, they could have movie sets. They could have all kinds of dialogues. They could have all kinds of stuff. And quite frankly, I want to turn and burn my unit as quick as I can. Dealing with abandoned personal property valued at over $700 with a death in the unit could take 6 months to rectify, if not longer. In my opinion, I want to flip and burn my unit as quick as I can to start getting money coming back in.
You know, most of my properties don't have. I work in the inner city, so.
Hey, you never know. You never know.
All right.
I
Patty,
think we
will
could also do
the
that for-
addendum be for the fridge be on your website?
No,
Oh, okay.
because it's that simple as I want to use my own at this time. Why would I do that? You know what I
Got
mean?
Yeah.
Well,
Okay.
I'm sure that the
Oh.
legal entities will have it on the boilerplate leases because it's a law now. You know, right now there's two
Hey,
places on
take
the
a
car
deep
lease.
breath. Take a deep breath and think about this. Water heaters aren't on there. Neither are dishwashers. We provide them. Garbage disposal. See how this works?
Well, yeah, yeah.
See? Oh,
Well, on the car lease it says they will not repair, replace, or maintain them.
yeah, it's bullshit because they will now.
Well, that's my point. So it's on there stating that, and I primarily use the car stuff for the most part.
Right. Because that's what we used to say is that the owner's refrigerator
Yeah.
and or washer and dryer is there for the tenant to use. And in the event that it breaks, that the owner will not replace it. We can't say that anymore. We have to change the verbiage.
Well, that's what the attorneys at CAR are for. I know that there's some new stuff coming out in January. I got an email from that law firm that does a lot of stuff. I haven't read it, but I'd imagine because it's now a law, it'll be on the standard forms.
Yes. Hopefully the attorneys aren't too busy with their holidays and they can get that up by January 1st.
Yeah.
Yeah.
All right.
It was me being as nice as I could have, saying good luck if you think that's going to be there by 1/1, but we'll see. Fingers crossed. I'm trying to on my end, but it's a very simple addendum saying that the tenant's going to use their own at this time. It's that simple. Don't overthink it.
Yeah. If they're going to use their own. Yeah.
Also, if you're a day or two late, or even, let's be honest, a few weeks or something, it's not really going to be the end of the world. Just you do want to get it in writing, though.
Correct. Absolutely get it in writing. Otherwise, who's to say that they're not going to be a LLPOF? You guys all know what that is? LLPOF, liar, liar, pants on fire, and say that their refrigerator hasn't worked since January and they don't owe rent. That addendum's important, in my opinion. I've had attorneys tell me it's not required because it's only on lease renewals or new tenancies. A freaking tenancy renews on a month-to-month, monthly. So everybody has a different opinion of what that means. There's no case law. There's nothing set in stone. This is new. So I would just cover your asset to the best of your ability and put the addendum on file. And if you never need it, yeehaw, we didn't need it. But if we did need it and you put it on file, you're welcome. Now you understand my theory of just do it? Because what's the worst that's going to happen to you? Nothing. Okay? What's the worst that's going to happen to you if we didn't do it? Ooh. See? Okay. So just do it. Have them put that addendum on file. Tenant wishes to use their own. You can even send them a message right now and tell them, hey, I need you to send me or send out an email. This new law says I got to put something in there. Unfortunately, it will not be up to your standards or such a nice machine as you already own. I would just be putting in a very simple, basic model. So,
Patty, so we could do it via email?
send them an email telling them.
Mhm.
Then you have something in writing. And I know it's not in writing, it's an email, but let's face it, courts are starting to look at emails and text messages a lot more than they should have. And remember how they wouldn't watch a video in court and you couldn't play a video off your phone in court? You can now. Remember them old school projectors from when we were in school where the teacher would put a piece of paper on the projector and then be able to write in the answer and we could see that answer up on a screen. They're putting their cell phones on that, hitting play, and it is putting it up on the screen in a courtroom.
Yeah, well, with deepfakes, it seems like permitting videos without making sure there's an evidentiary basis seems a little sketch, if you ask me.
I understand where the legal portion of you is going to come in right now, and I appreciate that more than anything. But I'm telling you, this shit's going on in small claims court. I know because I went up against it.
Well, yeah, it's always more informal too. So,
Exactly,
I
but it
sent
still
you.
didn't make me look good when the tenant freaking pulled out her cell phone and played this video. And then she had a video of the whole house of everything that was messed up except the 2 bedrooms she destroyed. And she said, "Oh, my video stops here." And I said, "Isn't that convenient? Why isn't it showing where all the damages were?"
Hey, I sent you what CAA has a whole like instruction thing about abandonment of real and personal property. So,
Okay, I see that you just sent that to me. Whoever had that question, send me a text message and I'll forward to you what Chris just found.
Well, okay, thanks.
No problem. Anybody else?
Patty, speaking of small claims, do you
Small
have
claims
to?
sucks.
Oh, great.
I'm
Uh-oh.
going to tell you guys right now, send out your right to an initial inspection.
Yeah, I did
Make
that.
sure you keep a written copy. Okay?
does that have to be like personally served or?
Snail mail. But I'm now going to start posting it so that I have a proof of service.
But in the courtroom, because on Fast Evic's paperwork, it says, obviously I'm going to have a packet of my notes. I have to provide a copy to the judge of my packet of notes. Do I actually have to provide a packet of notes to the people that I'm suing? Because I've been in small claims and I'm like, no, you should have put your own notes together. I'm not giving you my notes. And I didn't have to the first time I went for a personal matter.
Any evidence that you're going to submit to the judge, you should be submitting to opposing party also.
Right, but
But that's not.
sandbagging. Have it ready for the hearing, but don't just like volunteer it.
Well, that's only
Okay,
for them
got
to
it.
view it, not a whole packet in papers. Like in the hallway, you say, "Here, this is what I got." That's what I've done.
Yeah, right,
That's
but
sufficient.
you may get ordered to give them a copy of it, or you can't use it. So, I would
Okay, I'll
be
go in
prepared
with
for
it, but I
both.
just don't want to voluntarily give them my. I mean, they have it technically. It's, text messages, everything I've served them, but obviously I, put in the time to make
Right,
it.
but sandbag them. Like, absolutely don't provide it in advance.
Okay, got it. Thank you.
All right. I see that we're at the hour. If nobody else has anything, I'm going to get off of here so that you guys have a break from me, a little bit of respite. I am going to be live on a webinar tomorrow with Agla with dealing with a death in the property. I am hosting the webinar in Dan's absence. I am not teaching the webinar. So if you see my name come across the screen for some webinar tomorrow regarding a death in the property, that is not me, but I am live with Agla next week doing a webinar on understanding the written terms of your written rental contract. What I'm doing is taking them paragraph by paragraph and telling you in simple English what it means to you. Like, wouldn't you love it if somebody actually explained to you the attorney's fees clause and let you know that if you put $5,000 there, that's how much you're going to pay them if you lose? So understanding the terms of your rental contract next week, live with Agla. I believe it's free if you're a member with them, just so everybody knows. I'm really excited about that. And then I'm doing a death in a unit tomorrow with Bio SoCal with Agla, but I'm just hosting. I'm not teaching. Okay. Anybody else have any questions for me, or I'm getting off of here, letting you guys go enjoy your day? And I will talk at all of you soon.
Thanks, Patty. Bye.
Bye, everybody.
Thanks, Patty.
Patty. Thanks,
And
everybody.
I'll see you next week too. Bye, everybody.
Bye.
I love our team.